Houston Maritime Attorneys, maritime injury attorney proudly serving the state of Texas. At Patrick Daniel Law, our Houston maritime injury lawyers are well equipped to handle difficult maritime injury cases that other Houston maritime law firms find too complex. Houston Maritime Injury Law, also known as Admiralty Law, has a lot of quirks and inconsistencies. It takes an experienced maritime injury attorney to be able to see these inconsistencies, and we find them in every case that makes it to our Houston law office. Houston maritime workers are at a disadvantage in some maritime cases. In other maritime injury cases, they have some advantages in their favor. But only a skilled Houston maritime attorney will be able to figure it all out. So, whether you're in Houston, Harris County, Pasadena, Baytown, or the outlying suburbs, Houston, maritime attorneys. Maritime lawyers in Houston are plentiful, and they know admiralty law, maritime law, inside out. But experience is key. But this process requires more than a successful courtroom attorney. Maritime work is grueling, unforgiving, and raw, and any Houston, Texas lawyer who aspires to represent maritime workers had better know the work as well as he knows the law. The basics of maritime law. Maritime law is derived from many sources, including federal statutes and general maritime law. These sources provide some of the maritime doctrines that are commonly used in cases involving vessels and their passengers and crew. Maritime law and admiralty law are the same thing. So, what does maritime mean anyway? Maritime regards anything connected with the sea. This can be applied to commercial shipping and transporting or military activity. The set of laws governing maritime activity is known as admiralty law, a term used interchangeably with maritime law. Maritime law does differ from the law of the sea, which governs international trade, mineral rights, jurisdiction over coastal waters, treaties, and relations between countries. Admiralty cases are more local in concept, involving civil suits, individuals, companies, and representatives of those companies. Types of maritime injury cases. Maritime workers face situations and endure conditions that would send most landlubbers into a state of fear and despair. While for the most part, they understand the hazards they are exposed to and have various ways of coping with them and minimizing the risks, accidents do happen. Among the most common injury-producing accidents suffered by maritime workers are slip and falls solidly. No one in injury claims. In wet conditions, slips are common and occur on stairwells, on decks, and even in crew areas. Bumps and collisions. Swinging booms, cranes, dollies, carts, machines, and unsecured cargo can bash into workers. Lifting and carrying mishaps. A tilting deck and rolling seas can make lifting heavy objects treacherous. Even under ideal conditions, heavy lifting is a risky endeavor. Illness. Not every claim is due to an injury. Sometimes crew members become ill due to unsanitary conditions and improper food preparation. When to call a maritime lawyer. The quick answer to the question of when you should call a lawyer after an accident at sea is as soon as your ship docks in Houston. If you have cell phone Wi-Fi access and the privilege of making personal phone calls on board, call or contact an attorney as soon as you can. If your ship allows workers to make personal calls, the management cannot take action against you if you use your time to call an attorney.